A major development today, a federal judge has formally ordered a pause in the Donald Trump criminal coup case led by Jack Smith. As you can imagine, this is a big deal, and we're going to walk through exactly what's happening. The judge has effectively and legally paused the proceedings in her own courtroom until a key claim that Trump's lawyers want adjudicated, their argument that she has already rejected at the district level, that he is somehow immune to this whole case. Well, this is paused until the Supreme Court answers requests to deal with it. Now, this is a procedural ruling. It doesn't tell us whether there will be a Trump coup trial or whether that trial will result, of course, in a conviction or a mistrial or an acquittal. We're not there yet. What I can tell you is this is a big deal, and it is probably the largest procedural win for Trump's lawyers in this case. And by the same token, it's a pretty rare setback for special counsel Jack Smith, who has actually been on a winning streak on many issues. And I can remind you some of them. They won the gag order. They won on the evidence. They say they have Trump's cell phone records and other materials. Previous criminal questions that went to the Supreme Court cited for prosecutors that he has to cooperate and provide materials and evidence. So there's been a lot of wins up to this point. But Trump's lawyers clearly got a shot in the arm today. Now, the substantive question is one we've discussed and that many lawyers don't think they ultimately would win on, which is that they are arguing that Donald Trump as president should be immune from this whole process. That's the substance. But the reason why this is a big story, and it is a big story that may help Donald Trump in his plans to try to delay this whole thing, this whole coup trial, is the procedural side. So whatever's going to happen on that immunity question, they also have tried to take different measures to slow down the case, to punt or delay it. Now, Jack Smith beat them when they first tried that because they asked Judge Chutkan to have a much later trial. She said no. But right now, tonight, and this is the first time we've ever reported this in the pendency of this case, the whole thing is on pause. Now, you may remember Jack Smith did first go to the Supreme Court to try to step in and say, look, cut to the chase, get the high court involved earlier than usual to decide this question, which Jack Smith thinks they can win, that they think Donald Trump doesn't have immunity from all and any prosecution. But with the Trump lawyers trying to get delays, they now have the case paused by the judge. The pause does not affect the conditions of Trump bond. The bond conditions just stand, even though the actual jurisdiction here and the process of the case is essentially paused. The gag order still exists, but there will be no more movement in this case, according to the judge, unless and until the Supreme Court responds. We can also say that Trump's lawyers have a due date very soon this month to give their response to Jack Smith saying he's not immune, and the high court, should get involved. As you can see, this is a big development, and as I said, something a little unusual. We've charted a lot of Jack Smith's progress. This is, at least temporarily, potentially, a setback. I want to bring in Christy Greenberg, former deputy chief of the criminal division of the SDNY, and Emily Bazelon, legal writer for New York Times Magazine. Welcome to both of you. Emily, lawyers work with precedent. There's not a ton of precedent in this area. You go back to Nixon sometimes as the other incumbent who dealt with serious criminal accusations and then was pardoned precisely for the reason that Jack Smith says they expect to ultimately win. He took the pardon because he didn't think he was immune. If he was immune, obviously, Emily, he wouldn't need a pardon. So I'm curious if you could speak first to the procedural benefit to Trump as a defendant here. They're trying to get more time. And then second, to where this all goes substantively.
Right. I mean, the procedural benefit is delay. And for Donald Trump, that has a couple of different implications. One is that he can campaign for president for the Republican nomination without having to participate in proceedings in this particular case. Mind you, there are other criminal indictments out there, but in this case. And the second obvious benefit is that if he is elected president and then is in control of appointing who becomes attorney general and ultimately in control of the Justice Department, then he could make these charges go away, either directly or indirectly. And we know from things he said that he intends to exert a more direct form of control over the Justice Department than presidents have done for generations. He is telling us that's his plan.
Yeah, and Christy, this delay is well known. I mentioned the other day, lawyers do this in cases large and small, sometimes against the interests of speedy justice. I want to play for you just quickly how we've wrapped up. This has come up before. Trump's lawyers always trying to delay. Take a look.
Delay, delay, delay has always been Donald Trump's legal strategy.
His best defense here, his best strategy is delay.
Do I think that they'll try and push it and push it and push it? Absolutely.
So they got Jack Smith and his team got a fairly fast trial schedule here with a March trial date, but that now, as of tonight, is at least paused until the Supreme Court weighs in. How effective do you think this delay tactic will be? And as someone who's run so many criminal cases, what do you think they're thinking inside Jack Smith's team right now tonight?
Well, I think they've been anticipating that this was going to happen, that there would be a stay of these proceedings. Again, I mean, Jack Smith's team made those concessions in their own briefing. So Jack Smith's team went to get ahead of this. They have not only gone to the Supreme Court, they went on Monday to try and get an expedited review to skip that middle review, the D.C. Circuit, and go straight to the Supreme Court, just like they did in the United States.
Can I slow you down, Christy? Only moderator's privilege. But when you say the Smith team made a concession, are you referring to them saying that jurisdiction would be paused? Explain what you mean there, please.
Well, they seem to concede the fact that the trial, at least, would be stayed pending appellate review in their papers. So, I think they saw this coming, that not only the trial would be stayed, but also the pretrial proceedings as well. And so they went to get ahead of this to try and get an immediate appellate review, not only from the Supreme Court, but they've also gone to the D.C. court. In the event the Supreme Court says, no, we're not going to do this, you have to go through the D.C. appellate court, they're asking for expedited review there. So they are not sitting on their hands. They are moving with haste to try and get this issue, very discrete issue on appeal, presidential immunity and double jeopardy, heard as quickly as possible so that, yes, maybe there's going to be slippage in the March 4th trial date. The judge seemed to concede that in the decision today. But she said, importantly, that those deadlines are on hold. They are not vacated. And that whenever there is an appellate decision, she will revisit whether or not those need to be continued at all. So hopefully, I think both courts, I think the Supreme Court will hear this. It is an important issue that both parties concede is important. And so hopefully they follow the same model in Nixon and take it up rather quickly. In that case, in Nixon, they granted the cert to hear that within a week.